Afternoon, everyone, and welcome to this meeting of the Committee of the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair. We'll begin with a roll call of committee members in alphabetical order. Judge Espinoza,
Present.
Mary Kennedy, you're on mute.
Present.
She's new, but she'll get the hang of it. And Senator Wiener is going to be joining us shortly. Unfortunately, we got a call from Assemblymember Bryan's office, and he is unwell, but will be with us at the next meeting for sure. Today we have a lighter agenda than usual. Our main topic will be about disqualification of judges in criminal cases under Civil Procedure Section 170.6. This is otherwise known as papering judges. We'll have a panel discussion on that topic here, and then we'll hear from staff about research and other updates, and then we'll conclude, as always, with public comment. As we begin, Tommy wants me to emphasize our reminder about Bagley-Keene Open Meeting Act. As required by law, members of the public can watch and participate in this meeting at the first floor of the conference room in 925 L Street in Sacramento. Thank you, Megan, once again for being present at that location. And as a reminder to committee members, the law requires that members of the committee, quote, visibly appear on camera, unquote, during the meeting unless there are technical difficulties or a screen is being shared. If you have technical difficulties, please let me or Tom know, and we'll handle it from there. Cool? Cool. Before we turn to our business of today, I want to welcome a warm welcome to Mary Kennedy, our newest member of the committee, who was recently appointed by Governor Newsom and joins us most recently as being Chief Consultant for the Senate Public Safety Committee. Mary, welcome. I'm very excited to have you join us. And I know that you have a wealth of background and experience and knowledge deep in this penal code that's going to serve us well. So thank you and welcome.
Thank you.
All right. Now let's turn to the main agenda for today, which is about automatic disqualification of judges under Civil Procedure Section 170.6, also known as papering a judge. California is one of a small minority of states that permit attorneys to automatically remove a judge in a case simply for the belief that that judge is prejudiced against their client or the people. California is only one of 6 states that allows blanket challenges of judges, which is systemic disqualification, preventing a judge from hearing certain types of cases or all criminal cases. And it appears to be the only state in the country where this blanket challenge practice occurs with any regularity. While automatic disqualifications have been part of California law for over 65 years, they present unique issues in criminal cases because of the ability of the prosecutor or a public defender office to bring blanket challenges in covering all cases. The California Supreme Court has recently agreed to hear the legality of blanket challenges, and other states have taken recent steps to discourage blanket challenges in criminal cases. For me, blanket challenges raise a serious question about the appropriate administration of justice, and they happen with a surprising amount of regularity in actually large counties affecting hundreds, if not thousands, of cases. So I look forward to exploring these issues today. And with that said, let's introduce our panelists. I want to thank, are we promoting them, Tom? I want to thank all our panelists for joining us, as always, and sharing your insights with the committee today. As always, each of you, I'm waiting for you guys to get on the screen so I can look you in the eye. Hi. All right. Welcome, everyone. Please, if you would limit your opening remarks to five minutes, that will really benefit everybody. And we'll reserve the rest of the time for Q&A with the committee members and staff. And really, that's where we find the most useful part of the conversation. Of course, we want to let you say your opening remarks, but then we'll move on from there. So our panelists are Judge Daniel McGuire from the Yolo County Superior Court. Hello, Judge McGuire. Kathleen Gunaratna, how do you pronounce your name?
Yeah, Gunaratna.
Gunaratna, welcome, from Alameda County Public Defender's Office. The District Attorney of San Luis Obispo County, And the incoming president of the California District Attorneys Association, Dan Dow. Hello. And then retired Judge Dan Bunch from Oregon's 13th Judicial District, who joins us from our north. Judge McGuire, if you would kick us off, you have 5 minutes. Please take it away.
Good. Let me just start off with an audio check. Can everyone hear me okay? Good. Thank you. Well, I want to thank the committee for their interest in this topic and thank my other panelists. I think it is an important topic. My interest in peremptory judicial disqualification began when I was presiding judge of our court. During that period of time, there was a blanket disqualification of one of our criminal judges. I found it to be highly disruptive to court operations. Indeed, at times, it was the single biggest operational challenge that I was dealing with. I want to talk about a couple ways I found it to be challenging. First, it was very operationally challenging. To understand why, I think it's important to understand how California superior courts operate. We're always a bit on the knife's edge of operational feasibility, in my view, in that we have enough resources, but just enough resources. In order to staff a courtroom, we of course need all the back office staff. We need a courtroom, no problem with that. We've got a beautiful courthouse here in Woodland. We need a court reporter. That can be a challenge these days. We need a court clerk. That can occasionally be a challenge as well. There have been labor shortages. We need a bailiff. Sometimes that's an issue. And we need a judge. And there are natural disruptions that can occur. People can get sick. There can be labor shortages. There can be worldwide pandemics. All of these things can come into play and make it hard to put everything together so that when the litigants come to court, we're ready to hear their cases. And that was always my goal as PJ, to make sure that cases never got continued because we weren't ready. We do have enough judges, I believe, in our county, but just enough. I consider us like a basketball team with 5 players. We don't have any subs sitting around. And so if we have everyone there, we can make it run. When we had the blanket disqualification of one of our criminal judges, that meant instead of 4 criminal judges, I essentially had 3 for a period of time. So it's a 25% reduction in our ability to handle cases. And it was very, very difficult. The second challenge I'd like to just briefly highlight here concerns the presiding judge's authority to make judicial assignments. The government code and the rules of court says the PJs decide where judges are assigned. For my part, I thought quite a bit about judicial assignments. I had a system in mind. I felt like I knew what judges needed and who was good where. I was very much in favor of rotation so that our judges could be cross-trained and so that they can handle any different case type, which is important for a smaller court of our size. But when there's a blanket disqualification, now institutional litigants have a veto power over the PJ's decision. And so the PJ retains the responsibility for making assignments, but not all the power. The power is somewhat shared in a sense because institutional litigants can essentially veto the PJ's choice. And that, I think, usurps the PJ's power. Now, you might think, is this just a problem in one county? I don't think so. I'm the co-chair of a California Judges Association subcommittee looking at 170.6. We haven't reached any conclusions, but we have spoken to some PJs, and I wanted to share with you some comments from some other PJs. From Amador, the PJ there reports that blanket disqualification has had a negative effect on administration of justice in many ways. If one criminal judge is on vacation or out on medical, we are unable to secure an assigned judge. All matters have to be continued. There can be no consideration of pretrial release, no criminal protective orders. People who should be released on bail, people who should be released per the bail schedule, they have to wait for a bail review motion. Defendants who are ready to enter pleas could be continued. In Contra Costa, the PJ there reports there's been a disqualification going on there since this year, and it has significantly impacted the work of the court in that branch and has resulted in serious issues regarding access to justice, as nearly all the defendants in felony cases, their counsel, and all witnesses, including victims and officers, are required to travel a substantial distance to the courtroom. The blanket disqualification essentially puts out of business an experienced, capable judge who is a leader in our court. In Humboldt, huge impact on our small court. It already overburdens staff and judges. It is disruptive and causes chaos. which might be the point, I suppose. It results in constant rearranging of calendars and staff, the amount of time that goes into constantly having to redo calendars. It's almost a full-time job in and of itself. In Lake County, in a small county, the challenges are difficult to deal with. The frequently challenged judge does not carry the same caseload as the other judges, and challenges can be used to manipulate the system. In Lassen, as a two-judge court, it is very problematic. It necessitates having to bring in a visiting judge or two. In Marin, blanket challenges attack judicial independence. When judicial officers with a more diverse background are included in the bench for the first time, there is a risk that unconscious bias will result in erroneous preconceived notions about the values and aptitude of the new judge. This results in holding that judge to a higher standard of compliance. 170.6 challenges require a supporting declaration signed by an attorney. Just because I say the judge is biased should not be sufficient. In Merced, at least one case I am aware of was dismissed because of a blanket disqualification, and the caseloads of the other judges increased beyond their capacity to handle them. The effects: 1, judicial resources are not efficiently used. 2, unbalanced and inequitable workload for judges. 3, delayed or lack of access to justice. And 4, lack of opportunity for reflection and corrective action, because blanket disqualification doesn't provide a reason necessarily. Blanket challenges do nothing to educate judges and give us no opportunity to reflect and make improvements. From Orange, am I out of time?
I'm loath to interrupt a judge.
That's
But we're up on time. But I do want to. Your point is taken.
good.
That this is a widespread issue of concern to PJs across the state, particularly small counties, but even some big counties. I know you were just getting to Orange. In our memo, we mentioned Alameda County, San Francisco County, Sacramento County have all had blanket challenges that have impacted operations. So
Good.
We'll talk more as conversation goes on.
Thank you.
Thank you. Kathleen, I'm sorry, I'm going to murder your last name, so I'm just going to call you by your first name and ask you to take it away from and remind
First
me.
name is fine.
But remind me again what you're. Because I feel badly.
Kathleen Gunaratna.
Gujaratna. I'll get it eventually. Your 5 minutes starts now.
Okay, thanks. Thank you for having me. So we have a different view on behalf of the Alameda County Public Defender's Office. We believe that the 170.6 challenge promotes actually public confidence in the judiciary and in the perception of fairness. When I was a line attorney and public defender, I would frequently exercise 170.6 challenges before jury trials because I harbored a good faith belief that the particular judge assigned for trial was not going to be fair in sometimes a particular kind of case. Other times, my client actually harbored a good faith belief that the judge may not be fair because oftentimes the judge had presided over the preliminary hearing. And I value those client insights, and it's important that our clients have faith in the legitimacy of the judicial system, regardless of outcome. And I don't believe that the other substitutes, such as a for-cause challenge under 170.1, is an adequate substitute, nor are CJP or Commission on Judicial Performance complaints, for a couple of reasons. One, a for-cause challenge is impossible to win. We've never won one under the general catch-all provisions. The test sounds easy to prove, but in theory, demonstrating actual bias or demonstrating actual prejudice as opposed to a good faith belief in it is quite difficult. It also takes a lot of time. The judge has 10 days to answer. It burdens the judiciary because oftentimes the Judicial Council will then appoint an outside judge to preside over and adjudicate the challenge. It's not practical for an in-custody felony or misdemeanor client, and it overburdens the bench. But more importantly, we just don't win them. It also, a 170.1 challenge doesn't take into account implicit bias, which is what we see a lot sometimes from judges, particularly judges whom in rare cases we have exercised a blanket disqualification. I think one thing that the Racial Justice Act has taught us all is that, like all humans, judges can harbor implicit bias. And that is not easily challenged under 170.1, but we've seen it and we have examples of it. And in our county, the way the defense has approached blanket challenges has been a little bit maybe differently than it's happened for some prosecutors' offices. Our public defender, Brendan Woods, has always, our policy has been to try to talk to judges that we believe are genuinely exhibiting bias towards criminal defendants in general. And we have spoken to them with the prosecutor presence about issues that we're having, about comments that they've made, about practices that they have, some of which are maybe contrary to law, but some of which are just demeaning or intemperate or just simply biased against the public defender. And when those conversations have failed, sometimes we accompany it with a letter in writing, but at times we have exercised blanket challenges. And I think they are essential to preserving a fair judiciary. I mean, of course, defense challenges, even public defender challenges, are going to be a little bit different because even in the more than half of California's 58 counties that have public defender offices, we only represent about 80 to 90% of the clients. So our challenges, even when they're exercised in a blanket fashion, haven't had the effect in our county of necessarily removing a judge unless they're also accompanied, obviously, by court-appointed and public and private attorneys also exercising the challenges. But in rare cases where we have harbored an enduring and good faith belief in the bias of a particular jurist, and it hasn't happened frequently, but we do believe that if we have a good faith belief that the judge lacks impartiality against our clients, and it's not something that we're going to be able to handle any other way, that we would be simply derelict in our duty to fail to act and ensure that our clients got fair outcomes and a chance at fair outcomes. And I would say that oftentimes, well, we have also accompanied such a blanket challenge with a CJP complaint. And I believe the commission takes these complaints very seriously. But I would also note that my experience has been that these complaints take longer than 4 months to hear a response. Sometimes we haven't heard back for a year. The commission, I understand, is loath to intervene in pending cases, so they may wait until things are over. And they simply, having given trainings on judicial misconduct around the state for defense attorneys, speaking to them, people are very loath to file those complaints. With that, I think I'm at my time.
Perfect. Thank you so much. We'll certainly return back to you. DA Dow.
Good afternoon, and I really appreciate being invited to attend on behalf of the prosecutors of California. Of course, I don't speak for all 58. I'll give you my perspective that I think is shared by many of my colleagues. And first, I want to thank Ms. Gunaratne. Hopefully I got the name correctly. I think we share.
Show off.
I think we share the same viewpoint on this, and she was quite eloquent in it. And I would say that I started out as a junior prosecutor in Riverside County, where the time that I joined that office, they did have a blanket 170.6 going, and they had, over various periods of time, they had done that with several judges. And that was a large enough county where, while I'm sure it provided some difficulties for the court to manage that, it was one that they seemed to manage without extreme difficulty in terms of being able to supply enough judges for the courtrooms and for those assignments. In my role, I've been the district attorney, the elected district attorney, for 10 years, and I've always had the view that the 170.6 is an important tool for us in order to, just like when selecting a jury, that in a particular case, you feel confident that you have the right jurist, the right juror, if you will, the jury of one, to handle a particular case. And just like with using a peremptory challenge to a juror during voir dire, it may not be a bias, but it may be other implicit things, as Kathleen mentioned. It could be that there are, certain things about a particular judge that you, from prior experience, don't believe that they're going to be as fair in addressing perhaps an evidentiary issue. Perhaps their experience hasn't lended them to really be adequately trained yet for a particularly complex homicide, a multi-defendant case, cases with complex issues that they haven't yet addressed. And while that certainly would not raise to the level required for a 170.1, as Kathleen pointed out, it would mean that for us to feel like we have a fair jurist for this particular case, that it would be an appropriate use of our, I would say, well-reasoned and judicious implementation of our ability to file 170.6. I have considered over the last 10 years, a time or two, the possibility of implementing a blanket paper, but it has never gotten to that point in our community. We have on occasion had conversations with the presiding judge about issues that we were perceiving, in order to at least highlight for them some of our prosecutor's perspective. But we've never had a blanket issued in our community. We have almost gotten there with the public defender here in our county. The public defender is a contract of private lawyers, and they didn't have a complete blanket, but I would say about 70% of them were papering one judge for a period of maybe 4 or 5 months, about a year and a half ago. And I know that had a negative impact on our judges' ability to assign cases. However, we got through that, and I would argue that, similar to Kathleen, at the end, I think it increases confidence in the judicial system. The fact that we can only file one for the life of a case means that if you're going to use it as a blanket, you only have an opportunity to, if you will, stop one judge from hearing criminal cases in our community. And so it's limited in terms of its effect, albeit I would recognize it if I was on the bench. I'm sure it would be a frustration. But I do believe that the community feels like they can get a better shot at having a fair process if we have the opportunity to implement that peremptory challenge. And so I don't think I need to continue to use any more time. Kathleen really sufficiently addressed it. I'd be happy and look forward to answering any questions or getting into some of the discussion. Thank you.
Thank you very much. Judge Bunch,
Okay, am I on?
you are.
And I've got a timer on the bottom right, so I promise you I don't think I'll go anywhere near 5 minutes. I was just kind of taking notes as other people talked, but I do want to say I lived in 1997, if memory serves, in Vacaville, and I came to love Sacramento. For all of the people who are near that area, I just love the area. And I talk funny because I'm a Southside Virginian. Just so you know, I just happen to live in Oregon. And, I mentioned Vacaville because I was talking, and I don't see Joy's name up. I don't know if she's on or not, but
She is. I'm pointing at my screen. She's over
yeah,
there.
what a great human being. But in any event, I spoke to her, and the reason I mention this is I started in the military justice system as a Navy prosecutor and then an Air Force prosecutor, and you just kind of learn to live with what you got. And there were plenty of times I would look down and see who the judge was, and I'd go, oh man, this isn't going to be fun. And you dealt with it. And I think that's just part of professionalism. I wanted to point that out. Is we're all human beings. I'm a retired judge. I mean, I say retired, I'm still doing 7 weeks a year because we have a weird retirement plan. But I think I've been affidavitted maybe once, maybe, because I get along with everybody. And I mean, if we got bad judges out there, get rid of them at the ballot box. The other thing I would say, and I just kind of took notes as people were talking and things I wanted to address. I don't, and for the presiding judge who spoke, don't take this wrong. I don't care about courthouse operations. I mean, the courthouse can deal with that. To me, that's not the issue. To me, the issue is about, and it's what I testified to in front of the Oregon legislature, it's about bullying. It's not the judge that you're in, and I don't want to talk about individual affidavits. I didn't think that's what we were here to talk about. I thought we were here to talk about blankets. Okay. So I don't care about the individual ones. Lawyer has something to say about a judge, say it, own it, and have your hearing, whatever you want to do. But to me, when you blanket affidavit a judge, it's about the other judge. It's not that judge. It's the other judge saying, if I don't toe the line, this is going to happen to me. And that's just how I look at it. And to be candid, I'm extremely surprised that Kathleen is in favor of this practice, because I can tell you in Oregon, it really came, and again, with all due respect to the district attorney who spoke, in Oregon, it was always a DA who didn't feel like that he or she was getting harsh enough sentences, and they just do a blanket affidavit. And so to me, the message is to the other judge. And what is that message? You better be hard on criminals or you're next. And that just bothers me. I remember in Oregon, we asked the Chief Justice, because I was with a group of 5 who tried to change the legislature, and the Chief Justice just said, you guys don't have your act together. You've got a good idea. It's not going to go anywhere. We changed legislation our first time that we appeared, just with the 5 of us who testified. And I think it's because they could tell we all knew what we were talking about, and it was a real concern. I, I don't think, and I'm trying to figure out how to word this, I don't think a lawyer should be making a decision to do a blanket affidavit. I mean, it could be personal, it could be anything, but it just bugs me, because you have a lawyer. And again, in Oregon, what I've seen, it's the district attorney saying, I can't have a fair trial. Well, who's your client even? I mean, so you're saying that you don't even have a client you can discuss it with. Um, I, I mean, it disturbs me what Kathleen suggested, that you've got judges in California who are biased or racist. I mean, then get rid of them. Just get rid of them at the back, some way. But that just surprises me. I was a district attorney in Alaska, and we did, I say we, I had nothing to do with it. It was my boss. We did a blanket affidavit, and Alaska judges are not elected, they're appointed. So this guy had to fly in from Anchorage. And let me tell you, it was pure hell when he showed up, because he wasn't happy. So, so I became the head DA, and then I lifted the affidavits, and I just, told the guys in the office, we got to deal with the judge we have. And so that's just where I am on this.
Great. Thank you. That's 5 minutes. Appreciate everybody's insights. I do want to make a clarification that Judge Bunch made, and Ms. Gudaratne brought up the issue of papering an individual judge, an individual case. We don't want to talk about that. That we're not really considering that today. We're talking about blanket challenges and the challenges raised by blanket challenges. So I want to start off. Is there any questions from committee members for the panelists? Yeah, Heidi, Professor Heidi.
I understand what a blanket challenge is when it's coming from the prosecution side, but are there blanket challenges from public defenders' offices where they're not even consulting with their clients about it? They're just making, I view these as 2 very different situations. So I'm trying to understand, and maybe I missed it in the materials, but what exactly we're talking about when we talk about a blanket from the defense side.
Ms. Gudaratne? You're on mute.
So yes, public defender offices sometimes exercise blanket challenges where, generally speaking, I should say, I'm obviously only here speaking for Alameda County. I can't tell you what other public defender offices, what their position is on the blanket challenge. I know that, you know, obviously PD offices challenged it in Tejada and also in JO. But yes, if the public defender,
Without consultation with the client, just office policy.
if the public defend, and generally speaking, I mean, we tell our clients what we're doing and they generally support it. I can only speak for how it happens in our office, but in our office, it's a conversation. It's a lot of data collection, right? Where we're experiencing these things that seem unfair, biased, lopsided, disregard of the law. And, you know, it's not so easy to take all these writs or challenges or get rid of the judge at the ballot box. It's simply just not a practical thing. It's very hard to.
But it's done in consultation with the client.
Yeah, it's done in consultation, but it's generally at the public defender level. The boss, the public defender, will have, after we have a meeting with the judge and the DA there, and we talk to the presiding judge. Generally speaking, the public defender will then make a decision that we have a good faith belief that all of our clients cannot get a fair hearing in front of this particular judge.
Right.
And then we let our clients know that
You present that information to the client, and then the client could decide otherwise. I'm sure they probably don't often, but they could decide otherwise.
if we told an in custody client, you have 0% chance of getting out because this judge doesn't OR anybody, and
Right,
we'll
that's
let
a
you
factor, but right.
But yeah,
And you're not coordinating with the APD's offices or state appointed or privately retained counsel. This is just a policy within your office. And I think you said that's about 80% of the people appearing in criminal courts in Alameda.
I think it varies. It's 80 to 80. We represent about 80 to 85% of the clients in
Okay.
Alameda. I think the judicial council keeps records of that, and I think that's about the average.
Okay.
So where we're doing it, it doesn't result in the elimination of that judge doesn't lose.
Does it effectively put a judge out of business, or can a judge still have a criminal calendar if the public defender's office takes that position?
A judge in Alameda County, a judge can still have a criminal calendar unless the private bar also follows suit. And sometimes if a judge is exhibits extreme hostility or bias towards one side, sometimes other private attorneys will notice that too and will challenge.
Right. But just by the virtue of the fact that the public defender's office is taking that position, it doesn't put a judge out of business. Like, he or she could still maintain a criminal calendar.
Yes, I'll give you an example. Often they'll get sent overflow from other departments,
right?
Like a resentencing calendar instead or something.
Okay, thank you.
I had an empirical question. I don't know if Judge McGuire or Tommy or perhaps DA Dow, on these blanket challenges that we've seen, and again, they're not really reported, so it's hard to know for certain, but do we know, are they mostly filed by public defenders or prosecution or both, or do we know where it's coming from?
I don't think there's any statewide data that I know about. I don't know that it's reported. In our county during this period when we had a blanket, it was by the DA. There were hundreds of them. There have been ones by the public defender and county counsel also in our office, but I'm not aware of any statewide data.
Tom?
That's right. All of the examples we could find, which was just, through like local press, they're all prosecutor initiated challenges. That list is incomplete as we're hearing today. But
okay, so just to make sure that I want to make sure I understand at least. Very incomplete data. We don't know. We especially don't know the ones that we don't know about. But of the ones that we do know about, all of them are by the DA's office.
That's not true. I don't think that's true. I think there are challenges by public defender's office throughout the state and by county counsel and I know this is the penal code, but on the juvenile dependency side. So I don't believe it's all on one side.
But would you say that it's majority DA?
I really can't say.
Okay, we can't say. Got it. DA Dow, I just want to make sure that you're heard on this, but what's your sense on this general question?
Well, I would say I haven't followed a lot of the other counties in terms of the public defenders. I'm aware of a few of the DAs across the state that have exercised this from time to time. Again, I think their view on it has been it's to deal with a particular issue. It's not, as Judge Bunch would suggest, as somebody who's just light on sentencing. I would dare say I've never heard of a DA doing it for that reason in California. It's typically evidence-based. A judge maybe in sex crimes doesn't allow, under the law, under the evidence code, 1108 or 1101 evidence to be admitted because they philosophically don't like it and they've never seen a case where they thought that the probative value outweighed the prejudice. And that does prejudice the people in prosecuting a case. And so where I've seen it happen mostly has been with judges, essentially from our perspective, not following the law with regard to evidentiary procedures that are very important for us to have a fair case. And so that would, in what I'm suggesting, would preclude me at least from using a blanket, because that judge would be probably a good and proper judge for a non-sexual assault charge or a non-domestic violence case. But we may want to use it on a particular vertical kind of a case, because as with a person on a jury, that judge seems to indicate that, they're not going to give us a fair opportunity to present the case the way that California law and case law provides that we can. And so, again, that's, I guess, my comment on that question.
I understand. Ms. Gudratna, just again, just trying to get a sense of your office, though. It does sound like the Alameda County Public Defender Office has imposed blanket challenges on some judges.
Has a yes. In rare, I mean, it's very rare, but has.
And your experience of the DA's office in Alameda?
Well, there was something in the paper about one of the examples was that was in the memo was about a blanket challenge of a judge after he didn't go along with a plea bargain or something like that in Alameda. And I do remember reading about that, and I just don't know what happened. It seemed to have fizzled out because that judge was hearing cases.
At least you agree that this isn't universally by DAs, even though
it's not universally by DAs, in my experience in talking to other PDs. Although I think that if San Joaquin, obviously other PDs offices take a different view, and I think, but it's not universally, I don't think, a DA. I think sometimes the distinction, at least in my mind, a little bit. I don't know if this is true. I can't speak for those DA offices, but it seems like sometimes the real issue sometimes is the motive behind this, or the purpose. It does seem like there can be an abuse of the blanket challenge if there's an improper purpose in the challenge. We're certainly not trying to run somebody out of the courthouse or disqualify them from hearing every kind of case. But if we genuinely believe that our clients cannot get a fair hearing in front of that judge, and we have that belief and it's held sincerely, it does seem different than we're unhappy with what you did and we want to punish you.
I completely understand. My immediate question was just on the sort of empirical, who's making these challenges.
Yeah, I think we don't get the media doesn't cover, I guess, public defender challenges, blanket challenges in the same way.
Understood. Mayor Kennedy.
I was just going to say that I was aware of at least a few that the blanket ones that the public defender in Sacramento County has done over the years. And it was usually, my understanding of it from people I knew who worked there was that it was usually a new judge assigned to either had never done criminal cases, or one I know was suddenly in juvenile that didn't understand some of the basics of evidence or the laws or some of the changes. And so it would go on for a couple months, they'd get the judge new training, and then the judge was fine. So it was almost to get them to get to a point where it was clear they were never deciding, and I don't remember the particular things, but they just were not understanding the basic laws. And it tended to be someone who did not have, it wasn't a judge who was appointed from a DA's office or something who understood the law. It was a civil judge or former member or someone like that who came in as a judge and didn't understand the basics, and they had a gut reaction against the public defender clients.
So I think that we get the idea that there are remedies for bad judges, whether it's getting them out of office or appealing them or ridding them or whatnot. But those remedies are pretty cumbersome and slow and impractical. I was curious, Judge McGuire. I don't know if you were able to see the committee recommendation or from the staff, which was a general prohibition or against blanket challenges. However, well, Tom, do you want to summarize it? That maybe I'm getting it backwards. That you would allow blanket challenges, but they could be challenged, challenged either by the presiding judge or the judge who was targeted themselves.
Right. I think those are all options worth considering, and based very much on the legislation that Oregon passed that Judge Bunch mentioned, that you would require at the judge's discretion, because sometimes they may not want to object given the dynamic that's going on. But basically, the challenger would have to do more than just say, "I think you're biased." There'd have to be some kind of record made that would then be evaluated by a disinterested judge.
Why don't you answer that, Judge McGuire, and then Professor Romo?
Sure. So as I mentioned, the CJA has not taken a position on any solution, so I think we won't go into great detail. But remember, everything else in our legal system pretty much requires articulation and proof. And so this is sort of an exception to that. Of course, bias can be a problem, but so moving towards some sort of system where the problem can be addressed in a logical way rather than just a peremptory way, I think would be a great advantage.
Professor Romo?
All right, I'm going to start with a really short story because this issue has been on my mind since I first came to California. I was a federal prosecutor, so I'd done state court prosecutions in DC and federal prosecutions, and I ended up on a state court jury. And in that case, the district attorney was quite ineffective, and it was a challenging case to be a juror on. And I remember very specifically one day waiting in the jury room for 2 or 3 hours for the evidence to start. And then the evidence finally started and they were playing a 911 tape. They handed out transcripts to the jury and the transcript didn't reflect what was on the 911 tape. And the court broke for the day and gave the district attorney an opportunity to, for obviously the first time, review the transcript and compare it to the 911 tape. And we all came back the next day and I lost a day of work because I'm old enough that this was pre cell phones and Wi-Fi and laptops and things like that. And I went back to my office and I asked someone who had been a DA, I'm like, in federal court, you would move to your next witness or you would rest your case. Like that would be the option. And a judge had a lot of power to run an efficient courtroom for all the reasons we want our courtrooms to be efficient. And I told this story somewhat dumbfounded. And he said, you can't piss off the DA's office because then they paper you and you're out of a job, you're out of business. And that's a somewhat of an exaggeration, but I don't want to underestimate. I mean, I want to emphasize the point that Judge Bunch makes. It's not just an isolated incident where the district attorney's office has a particular issue with the judge. It is a signal to all other judges to a greater or lesser extent to accommodate the district attorney's offices in whatever ways they feel is necessary to stay on the bench or stay on a criminal calendar, or the consequences are very dire when it's a blanket by the district attorney's office because they bring pretty much 100% of the cases in that courtroom. And that's why I asked Ms. Gunaratne the question about whether if a public defender's office does this, it puts the judge out of business, and it doesn't. So it has less power as a threat or in that situation. But I think there's another important distinction, which is, when a criminal defense attorney is exercising it, whether for one client or 90% of their clients, they are doing it with the client's consent, presumably to protect, individual liberties. That, as Judge Bunch said, the district attorney's office client is the people. which is really the attorney making the judgment on what the people want, what they need, and what the what the stakes are for proceeding with a case in front of that judge. So I think I am generally in favor of putting this limitation on in some respect, but I do want us to think about the differences between creating, preventing a district attorney's office from exercising the blanket refusal and putting that on the defense side, even with when it's the public defender's office and they do have a majority of the cases in front of a particular criminal judge.
Thank you. I hadn't really given it much thought about the two different sides, and I'll get to you, Judge McGuire, and then DA Dow. I hadn't really, I thought it more or less thought that it was good for the goose was good for the gander. I'm surprised to the data very incomplete to hear that it seems to be largely, if not brought by DAs. And I am sympathetic to Professor Rommel's idea that the same people that the judge and the district attorney are empowered by the same people, right? The voters, as rather than the client. So all those are turning in my head. I'd sort of appreciate some feedback from you, Judge Daniels, and then DA Dow on those, and in anything else that Professor Rommel brought up that you wanted to respond to. So Judge McGuire, why don't you start?
Thank you. If a public defender's office was issuing a blanket disqualification of a judge, at least in our county, we'd have to reassign them because that's 80% of the caseload. That's not feasible. And I know operational details may not be the highest priority, but it affects other litigants. And the worst thing I can ever do as a presiding judge is go into a family law court and say, hey, no hearing for you today. You took your day off work, but I need to pull your judge and use that judge for a criminal trial. So the operational details, I think, are pretty important. Thank you.
Okay. Would you, do you have any, I'm not gonna let you off the hook that easily. I'm curious if you feel that there's a distinction in challenges by defendants or public defenders versus prosecution offices in keeping in mind the idea that judges are empowered by the people, DA's offices are empowered by the people, public defenders are empowered by their particular clients. So go ahead.
There's somewhat. I mean, it is true, of course, the DA is on 100% of the criminal cases and the public defender is only on 80%. But as a practical matter, if a criminal judge can't hear 80% of the cases, then we can't keep them in criminal.
I guess my point was more that if the DA thinks that this judge is out of step with the public, it's sort of, it's a little, it makes less sense because they're both elected by the same people. Whereas the public defenders are representing individuals who may not reflect the. Is that essentially how the gist of your distinction?
It's part of my distinction. It's part of my distinction. This is an individual, like a civil litigant who would retain, to make this decision, even though the public defender's office is driving or informing it with data. It is still the individual's decision, and you're protecting individual liberties and constitutional rights, or whatever the reasons are that the public defender's office believes they can't get a fair trial. But I also think it's the power that the district attorney's office wields. I take Judge McGuire's point that, in certain counties, it does put a judge out of business if the public defender's office, blanket papers them. But I had both those points in my, both of those of my.
Well, I'm not able to completely respond. I never worked in a public defender's office or a DA's office for that matter. So I don't know exactly how it works. But if each individual client were really saying, after being fully informed, I do think this judge is biased and prejudiced, that would be one thing. If it's more of an office decision that's made at a higher level, I think that would be something different. My understanding of the history of the statute is it was designed with individual litigants in mind and preserving and serving their ability to have confidence in the judiciary.
Got it. DA Dow.
Okay, well, thank you. And I appreciate Ms. Rommel communicating her concerns, but I'm taken a little bit aback at the comparison of our duty to represent the people in court not being on an equal playing field with the rights of a criminal defendant. There are victims in our cases that we represent as a member of the people. And then Marcy's rights under the California Constitution, victims have the right to ask the DA to actually represent their interests in court specifically, like with regard to a number of issues with their enumerated rights under the California Constitution. So I would hate to think that we as a legal community would diminish the importance of the client that we do represent. As an elected district attorney, of course, I'm representing all of the county, the people that voted for me, the people that did not vote for me. And I'm in office, hopefully, because of the vision that I set for the criminal and victim justice system and the application of justice in our community. And so I think that's my comment in terms of the client that we represent. And I think it's equally as important to be considered. And we don't represent the government. The government is not some, inanimate object, but we, the people that we represent, and it's an honor and a privilege to represent the people. And then with respect to it being abused, I have to respectfully kind of push back a bit. I could see in a very small county with 3 or 4 judges, it would be an incredible burden for that bench. And I would hope that it would not happen unless the stakes really required it. But in the medium to large counties, the impact on the bench is relatively insignificant. And so I would argue that it would indeed increase fairness. Judges are people. And if there are judges that have views very different from the other judges that are making more of the same mistakes, or what we might call a mistake, or having a particular bias, like I said, perhaps in a sexual assault case or a domestic violence case, important cases. In my view, you can only use a 0.6 blanket paper for a period of time, and then you're going to start over and give that judge a chance again to get back into criminal law. And so I would argue that it actually increases fairness for the community. And I can't issue a blanket paper against more than one judge at a time, because it's one paper, and I'd have to file that in every single case if I truly wanted that person to not be able to hear criminal cases. And so it has a shelf life in terms of its effectiveness. Could it be abused? Sure, anything in life can be abused. But to take away what I think is a very important tool to be used as judiciously as possible by people who, and a DA in whatever 50 of the 58 counties represents the people, I just think it's a tool that makes California stand out to have one additional layer of protection for the justice system. And in terms of the client consenting, I guess I'll just refer back to that being my comment at the beginning about representing the people, and they've chosen their representative. The judge, of course, doesn't represent the people. The judge doesn't represent the defendant. They represent, the impartial trier, and they get to make decisions, but they don't represent the people. And so I don't think the comparison to DAs and judges as both being empowered by the people is quite on an even playing field. Of course, 90% of them are appointed by a governor, and very few ever run, and at least in my experience, run in an open seat. They do from time to time. But again, I think it's just a really important tool, and my colleagues, by and large, try to exercise it judiciously. And I hope that the recommendations that are being made are not being done out of kind of a shift towards a negative view towards the people that go into court every day for victims of crime, and doing our very best to have a safe and secure community for California.
Of course. I'm reminded, you were saying, I have a comment on the question. I'm reminded of my mentor and one of the people I loved the most, Barbara Babcock, who founded the Public Defender Service in Washington, D.C. She would say, I represent the people too, just one at a time. So I think that there's some parallel there. I wanted to ask you more practically about the recommendation that perhaps we permit blanket challenges, however, that they're reviewable, that there is some process along the lines that Judge McGuire was saying to make sure that it's not being used weaponized, perhaps the way that Judge Bunch was suggesting, or used improperly, or overused, or maybe the presiding judge could say, like, listen, this is really messing up our administration here. Is there some way that we can negotiate this out to make it more reasonable? What do you think about that?
Well, I read that recommendation, and I mean, respectfully, I think that would essentially eliminate the blanket issue ever coming up again. I mean, I can't imagine a scenario where a bench would allow a office to exercise a blanket paper. So I think that would be an exception that would swallow the rule, and I wouldn't support that. I wouldn't recommend that. I mean,
because you're saying that it would be very difficult for a presiding judge to say, you're right, he is biased or she is biased.
Correct. I think they would basically always have a position of this is hurtful to our administration of justice, and we are, and you're using it in a fashion that's allegedly improper, no matter what the good faith belief is of the DA that's doing it. And so I'm concerned that it would essentially eliminate it, but it would look on paper like it was still an option available to the prosecutors.
I get that. I do want to get Judge McGuire's 2 cents here, and then Judge Bunch, because I believe this is the rule in Oregon. I'd love you to explain a little bit the rule in Oregon, how you think it's been implemented there. But Judge McGuire, would you start?
And I'm sorry to keep jumping in, but
no.
If there is a blanket and it's going on for a period of months, then there is enough time to do a CCP 170.1 and for the issues to be articulated and looked at, and perhaps for even the judge to even reflect on the issue. And so,
Do you agree with the idea that it would be tough for you as a presiding judge to say, Judge Romano over there, they are biased?
Well, it would be tough, but if it was true, I should find it. And we have to expect judges to do their job. And we do have a mechanism in the law which is used to disqualify judges for cause. And
right, but we're trying to make it not a cause. I don't think we want to get to, because we already have that cause exception. So the idea is to create this thing that's somewhere between peremptory and for cause, but that there's this good faith belief is, I don't know,
Right. Well, I guess then we would need to know what's the standard under which the presiding judge
of course, the devil's
is
in the
to look
details,
at it.
but the devil's always in the details, obviously.
And so it would vary. So, yeah.
All right. Ms. Gudrotny.
Yeah, well, I just wanted to respond to Judge McGuire, and how do I lower my hand here? We have tried the 170.1. It's simply an unattainable standard. It looks easy. It looks like it should apply to a lot of things that happen, right? That a person aware of the facts might reasonably entertain a doubt as to the judge's ability to be impartial. In reality, it simply doesn't work, and it is also a difficult administrable rule because of all the hoops it requires you to jump through. So it's simply not a viable option. As to the proposal, I obviously we're concerned about just blindly deferring to the presiding judge, who respectfully may understandably be more concerned about staffing courtrooms than fairness, and so that's concerning. When I do look at the actual Oregon rule, notwithstanding the belief that we think that because we are judicious in how this applies, and it's important in those cases where our clients need a fair hearing, which is all hearings, but I believe that if you look at the rule that Judge Bunch was instrumental in enacting, that establishes a reasonable good faith belief that the judge lacks fairness or impartiality, even if it effectively denies the judge assignment, that the motion could still be granted. I believe, thinking about the rare times that our office has it authorized a blanket disqualification, we would be able to satisfy that rule, because I genuinely believe that that was the motivation that we had when we were doing it. It wasn't because we were angry about a ruling, because we were angry that somebody had gotten maxed out that shouldn't have. I mean, if that were really true, we'd file a CJP complaint, or we would send a letter to the judge. It was not because we had some personal retaliatory goal or animus. And so I worry about the proof. I worry that some change will not be administrable. The nice thing about the automatic disqualification is it's just automatic. When you
Right.
get into the litigation, you increase
Of course.
inefficiencies and it becomes challenging. The details become challenging, but just as to whether or not I believe that when we have rarely done that, it would be in compliance with Oregon's test. I think it would. And I think maybe something like the way the court viewed what was happening in Tejeda was different. You at least get the sense that the court thought that was the Court of Appeal believed that might have been done for a different kind of purpose. I can't speak to that. I'm just saying that there are different purposes, and some of them are not legitimate, and I acknowledge that.
Thank you. Judge Bunch, I would like, unless there are other questions from the committee, I'd love you to just give us a quick summary of how you think things work in Oregon. If your 2 cents on this would be very helpful, and then we'll discuss as a committee.
Well,
so
and
thank you.
yeah, and we, can you hear me, by the
Yes.
way? Okay. Yeah, we're a small state, so I realize I'm talking to a state that's larger than a lot of countries, so you guys have a lot more going on. To be honest, since the law changed in Oregon, we don't have any blanket affidavits left. They just went away. And I think it's for 2 reasons. One, I think it got through to attorneys that you just need to work with the judge you get, figure it out. And the other thing, it's like I told one of the judges that I was working with to get the law changed here, I said, you got to be careful what you ask for, because when you push this and you ask the district attorney, and again, I keep going back to the DA, and I'm not, good grief, I grew up as a prosecutor. I love prosecutors, but I'm not picking on him. But in Oregon, it was always the prosecution. But in any event, if you ask that prosecutor to articulate why this blanket affidavit should stay in effect, careful what you get back, because you're begging for trouble. And so it's just, I mean, the problem has just evaporated overnight with the change in the law. And I'll be curious to see if there's another blanket affidavit, if anybody asks to trigger the law, because again, if you ask somebody to explain why they're doing this, they'll explain it, and it may not be pretty. You know what I mean? So, but I'd never, and I hope you don't mind me using your first name, Dan. It's actually my first name. Yeah, and I mean, I never saw it in Oregon based on evidentiary rulings. It was just judges who sentenced lightly or were quick to OR people. I mean, it was that sort of thing. That really, because attorneys would talk to me, they'd tell me why, because it was in my courthouse. We had a judge who was completely put out of business, and but he retired, and I don't think we have a blanket affidavit in Oregon as I speak, to be honest. Just went away.
That's super helpful. I really appreciate everyone. Because no good deed goes unpunished, Judge McGuire, I'm going to ask a favor of you, which is, and perhaps also this would go also to DA Dow from the DA's Association. To the extent that we'd like to try to get more, if data is not the right word, more examples of blanket challenges, could we rely on you, Judge McGuire, to work maybe through Judicial Council to see if we can get some kind of survey or questionnaire out, and vice versa for DA Dow? Might the DA's Association help us facilitate this, just to get a better handle on what's going on? Your thumbs up, DA Dow, I appreciate that. DA McGuire also thumbs up. Ms. Gudratne? Oh,
just in the interest of candor, I think you know this, but I should say that there is a diversity of opinion among public defender communities. So data points for those folks might also be
I'm not interested in who cares. I mean, I am interested. Of course I care what everybody thinks. I'm not looking for viewpoints of anybody. I just want to know how widespread this is and where are the challenges coming from, DA side or the public defender side. That's the data that I'm interested in trying to get our arms around if possible.
So just to confirm, you'd be interested in knowing statewide data as to the number of 170.6s and whether they're from DA, public defender, or other parties? You could get that?
Yeah.
Okay. Well, let me talk to Judicial Council and see if there's any way to wrangle that. I don't know if it's collected, but maybe it can be reverse
And it may
engineered.
be anecdotal. I'm conceding that, and that may be the best that we can get, but I would love to try to get to the extent that somebody might have better access to finding that out. In fact, I'm almost confident, I'm almost certain it would be anecdotal, but it might be better than what we have now.
Okay, thank you.
And Mike, you're talking about blanket challenges, not every 170.6,
Correct.
right?
Blanket
Okay.
challenges. I'm sorry to make that clear, Judge McGuire. Blanket.
Okay. Understood.
All right. Well, we can talk offline about how to make that request. And like I said, no good deed goes unpunished. We'll be in touch with all of you guys. Please, along with members of the public, if you have additional suggestions, encouragements, comments, whatever, please send them to us and staff. We really appreciate it. Thank you for your time and have a good weekend.
And thank you guys for including me. That was awfully nice.
Enjoy.
Yep.
Oregon.
Yep.
Great
I'll do it.
All
All
right.
righty. See ya.
All right.
Thank you. Take care.
So here's the next step in our process. I just want to spend a few minutes among committee members to prioritize and see how if we want to sort of continue to think about this idea. You got my gist that I would love to, if we can, before we have to actually finally vote on whether or not to make a recommendation, for example, my opinion would probably change if I learned that 90% of blanket challenges were by one side over the other. I think but I'm sort of curious about what you all think. So Heidi, Mary, Peter.
You probably you could ask the District Attorneys Association and Public Defenders Association to just put out a poll to their people, and they should be able to get, like, how many have you done in the last 2 years or something, or whatever period of time you want. And they probably, without, they could do it without saying even which county, but they should be able to give you, I would think that the Public Defenders Association and the DA's Association could get you some numbers.
And do you think that would be useful? I mean, is that useful to you?
Well, if you're looking for how many have been done and by whom, that would give you those numbers.
I appreciate that. That's my own concern. Yeah. But I'm just asking you as a voting committee member, do you think that's even relevant, or do you care?
I'm not sure. I mean, I guess all information is relevant.
All right. I just don't want, is the juice worth the squeeze?
Yeah.
I would want to be I am very much in support of preventing DA's offices from making blanket challenges. I guess I wasn't very shy about that in the meeting. But I would want to be sure. And if we impose that on public defenders' offices, I would just want to be sure we don't do anything that interferes with an individual defendant's right, like any civil litigant, to 170.6 a judge. And, and if it gets to the point where 80 or 90% of the public defender's office's clients are doing that doesn't somehow become construed as a blanket challenge, and then they're precluded from doing that. Because I do see a really big difference between having an office representing the people, and I don't think the victims are particularly weighing in whether or not they're 170.6ing the judges, with all due respect to victims in Marcy's law, and an individual, defendant or client being able to make that choice just like any other civil litigant would, where there's probably less at stake than in a criminal case.
So just to clarify, you would say it would prohibit DA's offices from making blanket challenges without cause, period. And individual defendants could continue, and if it got to a point, some tipping point where it became a de facto public defender challenge, and you have some way to ameliorate that. Is that basically what you're getting at?
I mean, I don't think you should, Look, it's an office and they collect data. And if they say to their client, this judge has never OR'd a person even for a misdemeanor, you should consider whether you want a 170.6. And that should not be prevented or precluded or limited in any sort of way. But I can imagine that at some point it's going to tip over to someone arguing it's a blanket challenge. But
Right.
that feels like extremely relevant data to collect as an office. And that seems like extremely important information for a client to have when they're making a 170.6. And a defense attorney should be able to recommend a 170.6 to their client. It's such a different set of circumstances that are driving these decisions. And I want to be mindful of that. I realize it's going to be much harder to pass legislation that, seemingly targets the district attorney's office. I get that. But I don't know I've thought about this for many years. I don't know what the solution is, but it can't be that individual criminal defendants no longer lose their 170.6 rights.
That was actually my exact concern. Was I think that basically what Heidi just said, it concerns me more that a DA may do it because they don't think this guy's a tough sentencer, or there's other things like that. Not necessarily the not letting in evidence that should be allowed in.
I mean, if it's that critical to their case, they can appeal that.
Right, they can appeal that. I mean,
right?
And the question is whether it's every time or whether it's a particular decision on that or something. But
right.
But my concern legislatively is a recommendation that just seems to punish the DAs and not defense with, because the people don't always discuss it well enough to understand it, is there will be amendments to that bill that end up either narrowing what's against the DA. It's a hard thing. I think that would be it's a tricky line to walk.
It's a tricky line
to get past.
Anecdotally, I've asked public defenders, like, wouldn't you love to get rid of this? Doesn't it give the DAs wield a lot of power with that?
Right.
A lot of power. Oh, and like the judge said, over judges, who don't have everyone's aware of that power when they're making decisions in their courtrooms. And I know it affects every judge differently, I'm sure, but I've asked public defenders, wouldn't you love to get rid of 170.6? And they're like, no, I want it for my clients. I need it. I want it.
Right.
So
we're never talking about eliminating the individual.
But what does it look like if a public defender's office?
But at some point it becomes blanket looking.
If they recommend it to most of their clients based on data they have, and 80% or 90% of their clients are making the individual choice to paper a judge, how do we protect that right?
I don't know. But it's partially, and Mary, we struggle with this all the time. What do we think is an ideal policy versus what do we think is legislatively feasible, and then what do we recommend? And I go back and forth about this all the time, and I think as a committee we're going to have an evolution of how to do that. Do we go somewhere sort of in the middle, or and on this particular issue, I'm being more and more persuaded by you, Heidi, and I wonder if we can blanket 100% are gone, are prohibited. Individual challenges, and make it clear individual challenges by individual criminal defendants remain. And then what happens with the de facto challenges is de facto every single time. I don't know, but I do know that Judge Espinosa has been very quiet on this, and he is a judge after all. So I'm curious what your take is on it.
Sure. And in my defense, I've been off the bench for 9 years, and I've been away from supervision for 15. But when I supervised the criminal
benefit of hindsight and wisdom and perspective.
When I supervised, I had trouble developing sympathy for the smaller counties, and that's my problem. But in Los Angeles County, on any given day, there are more than 280 judges hearing criminal cases. So accommodating affidavits are not a problem. I don't remember seeing a lot of blanket affidavits. I don't remember that being a problem in Los Angeles County, but I may just be remembering. What was required back in the day for the DAs to issue a blanket affidavit was approval from the DA. And that wasn't easy to get during most DA administrations. So I guess a law that says if the head of the office, prosecution or defense, says we are no longer
Fines.
allowing, yeah, we are no longer allowing this judge to hear our cases, regardless of the side, then that's a blanket affidavit. And I agree with Heidi that we have to protect the individual rights of criminal defendants to file affidavits. And the problem, again, in Los Angeles County, the problem didn't become a real problem because, you know, we had 12 geographic districts spread over 10,000 square miles or 4,000 square miles, whatever it was. And people were cautious about affidaving a judge in one district when it could result in the case being transferred to another district because of workloads. And that was not an idle threat. That was frequently, you know, what would happen. So we don't have anybody in your district to hear this case or these cases. And so they're going to be spread around. They're going to be moved to different places, which isn't fair to the litigants, particularly the people's witnesses. So I guess I come down on the side of maybe we should just limit blanket affidavits and do what we can to maintain the right of people to file individual 170.6s.
If we get rid of blanket, what does that allow the DA's office to do? Like then each prosecutor can individually paper in each case as they see fit. But isn't it the same problem we see on the other side where like everyone's just like, oh, hey, well, no one's bringing cases in front of that judge till he gets reassigned. You know, like isn't that how do we prevent a pseudo blanket, challenge? Like, how are we defining blanket challenge? That's, I guess, my bigger
Right, blanket
question.
challenges.
I have an answer to that question, but I would say you start with, was this process approved at the highest levels, right? Did somebody in charge say, yes, you no longer we no longer want you to take cases to that judge? But I don't know whether, Professor Rummel, if we eliminate blanket affidavits, there's any way to control what we are referring
Yeah,
to the de facto affidavit process, because
yeah,
lawyers on both sides talk to each other.
exactly.
And if they decide rightly or wrongly that they don't want to go there anymore, then there's not much we can do. And it is a problem in the smaller counties. Back before court unification, when there were all these little muni courts in Los Angeles County, I supervised one of those districts back in the 90s. And we reached agreements with other judicial districts to send cases when we couldn't accommodate them in our district. So I don't know.
In your experience, how real is the concern for judges about getting papered by the DA's office? Like, how much do you think that consciously or subconsciously affects their rulings and how they run their courtroom and how they accommodate DAs? Is it a big problem? Not a big problem?
Great question. Impossible to answer. It's so individual. So
But it's true for some judges, right? I mean, it's going to be true for judges.
it's true for some judges, but that fear dissipates with the amount of time served on the bench. I know that when I was elevated from the Muni Court to the Superior Court in 97, and we were in the middle of 3 strikes, and the DA's office in Los Angeles County was literally, well, to a large degree, controlling the justice system through that threat. If you strike a strike and it's not upheld by the Court of Appeal, we're going to stop.
You're done. Yeah.
But with Cooley's
That just feels so problematic to me.
Yeah, I'd have to check in with the leadership in LA County. I don't know how much of a problem this is these days.
Yeah, there's so much less discretion in sentencing than there was 20 or 25 years ago too.
Yeah.
All right. Does anybody have any further questions? Tom, Joy, Rick, do you guys have any 2 cents you want to add?
A couple points on the sort of eliminate prosecutors' ability to do it. That is what 3 states have done. So there is that precedent for it. It was even what the original 1930s version of this California law did.
So just to clarify, eliminating blanket challenges or any challenges whatsoever by the DA?
Well, two states specifically say no blanket challenges, and then one state says no individual challenges either. So couldn't do blankets either.
And how did they? But so in the states that allow individual challenges, a DA could say, in one case in front of a judge, I don't want you on my case.
Yes.
Okay.
Right. And the question of, what is a blanket challenge, what isn't, I think, it's just the classic legal line drawing problems. There has to be some playing the joints, whatever the standard is. What Oregon says is challenges that effectively deny a judge from handling a docket or something like that. So you can kind of try to specify a little bit that way, but it does get quite complicated, like we talked about, sort of in the judge who does arraignments or bail settings. If the blankets or the challenges are only to the judge in that context, would that count? I think probably it should, because if that's the judge who never ORs someone or never issues a protective order or whatever the issue is, it shouldn't literally just be no criminal cases at all. But if the judge's work is limited to one area of the system, that seems like a good place to look as well. But it is hard, and I think that's why the Oregon standard essentially has two questions, like, is it a blanket challenge, and then if so, what was the reason for? Those are kind of two distinct things that need to be answered, and I think that kind of makes sense, because there's no way to figure it out in advance, unfortunately.
All right.
It seems like there's something to requiring whoever is declaring the challenge to actually state something on the record about
Right.
why you're doing it, so that it could be assessed. Because right now, attorneys are literally just filing paperwork saying, we think this judge is unfair, and don't have to do any type of assertion. And so requiring people to actually say why they think is the judge is unfair, and then maybe even requiring like that the challenge be kind of narrowly tailored, because as the DA mentioned, like if it's, we don't think this judge is good on certain types of evidence, and we're not going to go there on these type of cases involving that type of evidence, that seems more legitimate than, we don't think this judge is good on that type of evidence, so now we're not going to criminal cases altogether. And so maybe like a provision requiring to be kind of the challenge to be tailored, to the whatever the basis of it is. And then as far as the statute itself, it seems like
Rick, I would agree with that if we're talking about a blanket challenge by an office, but in terms of individual criminal defendants, like you can't go in front of a judge and say he's racist or racially biased, and then you lose, and then you bring your case, and then there you are getting sentenced by that judge.
Right.
Yeah, that's true. I was just going to add that the current statute kind of has parties or attorneys to parties all kind of lumped in together, and that you could potentially revise it to say, here's the law that applies to attorneys, and it's the same. To Mary's point, it's the same for prosecution and defense attorneys, but here's a separate provision that applies to defendants themselves when they're making a challenge, so that
The defendant's always doing it through their attorney, though, so I don't know that works either.
Right.
I mean, I think the information on
public defenders, I think the idea is that, just sorry to interrupt, the idea is that public defenders could make the motion on behalf of their attorneys. They're not making it on behalf of themselves or the office. Is that what you're saying?
Me? Yeah, the current law as it is says that the party or the attorney believes that the judge is biased against them. So you don't know when a person declares a challenge, is the attorney saying that the judge is biased against me as a public defender? Or is the judge saying that, or is the judge biased against my client? So who's making that? Who's making the assertion? And if clarifying that, you could apply similar standards to the DA and the public defender.
And Mary, sorry, I cut you off.
I think usually what Heidi has pointed out is that the attorney's making it on behalf of the client, even if it's that this judge doesn't like me. Your client knows the judge doesn't like me, the attorney, or whatever. That I do think it could be helpful. I think some explanation at times can be helpful, or some discussion with the presiding judge about why this is happening. Because the couple circumstances, I heard about from people, it was always that this judge needed some more basic training. They didn't understand the courtroom they were placed in. They were new to criminal law. They were new to juvenile law. One I know was like placed in juvenile, and didn't understand the basics of, it was before, when someone was, made everybody become an adult or whatever. Like they just didn't understand the basics, and then they got fined with new training. So I think it would be helpful to the presiding judge to understand and to have those discussions. And I would think in some counties, those discussions do happen between the offices and the presiding judge, but it's very clear that not every county's DA and public defender's office and judges all work the same as they do in other counties. There's communication among some counties, and among those offices are better in some than others.
Maybe there's some kind of under seal procedure or something where only the presiding judge is considering the reasons. But there are some very personal reasons that you might not want to have a judge on your case. I would not want to file on behalf of a client if I wasn't 100% sure I was going to move to a different judge. It just prejudices you in the long run. So I think we have to just balance those interests. There are some really legitimate reasons, things you could say to a judge, I think, without them taking it personally. You don't have enough experience in juvenile yet or something, but there's some other reasons that I think underlie some of the papering that goes on that you wouldn't want to speak publicly for the judge's protection, for your protection, for your client's protection, for all kinds of reasons.
All right, we've gone around a bunch. Does anybody have any last thoughts? And then basically what happens here, just to remind everybody, is this kicks it back to staff, who will then sort of try to coalesce our very concrete and very directions, which I was being sarcastic. I don't know if but to keep on noodling on this basically, and then we will return to it next meeting and the meetings after that until November. Is there anything else people that want to add to that noodling process? Tom, you.
No, this is helpful because honestly, we weren't sure if there was going to be any interest in addressing this practice at all. So the fact that there seems at least to be a consensus to try to do something is great. So, I think we can just develop a little bit more all these ideas, and as we have in years past, we'll come up with something that is good.
And also to keep in mind, as Tom, you remind me often, we're not writing the legislation here, so we don't need to get into the weeds. And once the legislation actually is drafted, of course, the details will matter. We want to try to kick off with the most clear recommendation that we can come up with. All right. Thank you all. Before we turn to the presentations from staff, we have a couple of administrative items, or maybe just one, which is to approve the minutes from the April meeting, last month's meeting. Will someone second approving the minutes? Oop, Heidi's gone. Judge Espinosa.
Yeah, I'll second.
All right. She's back. Is anyone opposed to the?
I'm here. I'm voting.
You're here.
Off camera.
Anybody opposed? All right. Minutes are approved. Now we want to move on to presentations from staff. This is going to cover a couple of topics. Status of bills in the legislature related to past committee recommendations, some crime data, and a preview of our new data dashboard that we've been working on for a long time and very excited to show to you. So Tom, please take it away.
Yes, and obviously anyone, please interrupt me at any time. We'll try to get through these quickly. Okay, probably one of the worst days to try to give an update on pending bills, because this is the day the appropriations committees decided, what was sort of going to continue. So I won't go too much into these right now. It's the same list we saw about a month ago. I think already 2 or 3 of these are not going to continue, but I'll give a better update once the dust has settled on that at our next meeting. But a good place to start, especially in this environment right now.
672 came out of approps today.
Excellent. I think maybe with a few more exclusions, but still a very strong.
I think
bill.
I haven't seen them yet. Yeah.
Right. Okay, violent crime data. So we are able to look at just violent crime, not property crime, for the 8 largest jurisdictions in California. We can look at the first 3 months of 2025 versus 2024. And what we see is great. Overall, 14% less violent crime in those places in California compared to about 60 other cities outside of California. a little bit higher, but about the same drop and drops in every category. Now, first quarter comparisons are always the least reliable because of lag in collecting crime statistics. So we should take these with an even bigger grain of salt. But hopefully this is a trend that will hold up and continue throughout the year.
But these are still apples to apples, right? So we're talking about the first quarter for.
Exactly. Yeah, exactly.
Yeah.
And then I think last time when I showed this, Mike, you had asked to sort of, could we look at this data going further back in time? So I've done that with this chart here. So this goes back to 2020 and it's quarterly reports. So every 3 months. Sorry, 2010. Well, it goes back to 2020 and even further back. It goes back to 2010. And this is quarterly. Again, just violent crime, and it's in 7 big cities, so not the full sample. I won't get into all those details. And this most recent quarters right here, we see it's quite a bit lower than almost every quarter we see going back to 2014 was when violent crime counts were at their lowest. And so this also isn't adjusted for population. So as you go further back in time, there's actually less people, so the rate would be different. But whatever. This is just to give an overall big picture sense of the violent crime trends in those reports. So we seem to be going in a very good direction. All right, now let me show you the dashboards real quick. So a quick overview. So this is a tool that allows the person using the dashboard to look at people who are in prison right now, and also for all admissions and releases since 2015. So about a decade of data. Who right now we're in a very limited rollout. We've sort of shared it with folks in the legislature who might have use of this sort of in their day-to-day, kind of beta test it. I'm going to share with all of you all after this meeting, so you can click around. I wanted to make sure we, first talked about it in this public meeting before I did that. And it uses CDCR data. And let me give you a quick.
And of course, our friends in the governor's office have also, and to make sure that everybody, this has all been very carefully vetted with CDCR, and so they're all the relevant parties are very much aware of what's going on here.
Yes, and we've been working very closely with CDCR, and they've been great to work with, I will say.
And I double down on that. Thank you.
So this, and I won't delve into this too much, but basically this is what it looks like. Overwhelming a little bit at first. The key thing up here is this shows the number of people we're talking about at any one time. And then it shows, what those folks are convicted of, what the average sentence is. This shows how many have particular enhancements, and this is demographic data down here. The thing that makes this really interesting is you can customize it. So if you just want to look at, for example, just people from Los Angeles County, you would go over to the county picker, just click Los Angeles, and everything then updates. So instead of 90,000 people, we're looking at 26,000 people. If you just want to look at Black people from Los Angeles, click on that demographic detail here, and it will update. If you just want to, I'll do a sentence enhancement real quick. So I'll reset everything. We just want to look at gang enhancement. So keep your eye on the demographics, as they're going to change pretty substantially. So we'll see people with a gang enhancement, only 3% are white, so 97% are people of color, a finding the committee, has made many times before. And again, this is just the current population. If you click up here, you can see everyone admitted. The sentences tend to be quite a bit shorter, and then releases as well. So I'll share that with everyone. You can feel free to click around. If you have questions, let me know. But this is just a very quick overview of this.
And a very hearty hat tip to not only CDCR and their team over there, but to Tom and our friends at the California Policy Lab, who've been working literally for years on putting this together. And it makes nerds like me very, very happy and excited. I've spent many hours already playing with it, so I encourage everybody else to look at it. And yeah, that's enough said.
Great. All right, so now we'll move on to some research updates. So this is going to track the memo that Rick wrote that we sent out last week. I'm only going to highlight the ones that I think have risen to the top for discussion right now. But if anyone has questions about anything else, obviously, please let us know. We can get into it. Okay, so first I wanted to talk about retroactivity. So there was a recommendation from staff at our last meeting to basically allow retroactive application of this recent California Supreme Court case, People against Collins, which clarified the standard for convicting parents, particularly mothers, of homicide in a failure to protect theory. In our opinion, it made it harder to convict that and convict people of that in an appropriate way. So we suggested just making that retroactive, like the legislature has done a few other times for similar things involving domestic violence or intimate partner violence. And during that discussion last time, the committee talked about a more general retroactivity idea that sort of any change in the law should be retroactive. And, we went and probably ad nauseum detail about the current legal standards for this in the memo. But the thing I wanted to highlight now is that it's super complicated to figure this out. Courts sort of have been banging their heads against the wall for many decades about it. Doesn't mean we can't come up with something, but I think it's appropriate to acknowledge, the sort of theoretical difficulties this presents. And of course, we also now have quasi-retroactivity for all sentencing changes with AB 600, which has only been in effect for about a year and a half, that allows a judge to revisit a sentence if the law has changed. The issue there, of course, is that the person, a defendant or convicted person, can't make the judge consider it. They can request it and the judge can not respond, doesn't have to respond to it at all. But we're sort of taking a step in this direction. I think the question that we as staff have is, should we continue down the general retroactivity path, just focus on the more narrow idea around the Collins case, or something else?
So here's my recommendation, and I want to make sure that Mary Peter and Heidi all agree, is that I think with regard to the specific question of retroactivity of Collins, which again makes it more difficult to convict parents of murder in failure to protect cases. Should that be applied retroactively? And I think that we should make a recommendation that it should. And that furthermore, that recommendation should be separate from the larger question about should changes in law be made retroactive generally. I would sever the two issues, because I think the general retroactivity is more complicated than I would like. Although I take Tom's point that judges, lawyers, academics have struggled over Teague versus Lane and related retroactivity questions as an opportunity, and so almost an obligation for us to try to jump in and clarify that. So, and I might say that as a separate committee recommendation, either perhaps requiring separate conversation, but for purposes of, last month's meeting was really about accomplice liability, and especially the gendered impact of those cases. So I would really try to keep our focus on Collins for this recommendation, and then think separately, but not abandon the issue of general retroactivity. Do people have objections to severing the idea of retroactivity of Collins from the general retroactivity question? Seeing none, I think that's where we should go. Tom, does that answer your most basic question there?
For sure. And I think essentially the recommendation around Collins is fully cooked. We don't need to overthink it. And then we can sort of hold the more general discussion in abeyance, which is appropriate for discussion of retroactivity, continue putting things off.
Yeah, exactly. And I apologize for, I'm probably the one who may have instigated most of the general retroactivity question, but retroactivity, because it's stuck in my craw. And anyway.
Well, it comes up repeatedly, and obviously the committee, you all have made numerous recommendations about making things retroactive. So to address it globally makes sense, but also I think when Rick and I and Joy have really talked this over, it seems like we'd be replacing one complicated test with another. And how would that work? But maybe a general statement about it is helpful. And the legislature has I think made more things retroactive than ever in the last few years. So I think something's in the air about it. So it definitely makes sense why we keep coming back to it.
Great.
Okay, number 2 is on the coercion defense. So this is a relatively new affirmative defense created in the penal code that is a total defense to criminal liability. If you can prove it, you are not guilty under the law. And right now it only applies to nonviolent felonies. And it's also, I think, in our opinion, pretty undeveloped in the penal code. It's a sentence, not that long of a sentence as some of the sentences in the penal code are. And the recommendation we had in April was to try to develop it more, with the idea it might encourage its use and would help courts figure out how to evaluate these claims as well. The problem that Rick and I ran into is that doesn't really seem to be a real good roadmap from the experts about how to do that. And the reason we think it's important to learn from experts, especially on this, is we don't want to sort of guess about what would make sense for a coercion defense, given how complicated these cases are and given how powerful it is as a defense. So that's a little bit where we are right now with this. And I will say, and I'm not sure what happened today with it in the Appropriations Committee, but there is a bill right now pending from Assemblymember Mia Bonta to expand the defense beyond nonviolent felonies to all felonies except for murder. So that's where a lot of the energy on this issue is right now. So we're not sure exactly. The committee has a point of view, and we should continue this or similarly let this one sort of simmer for a little while.
I don't have a strong feeling about this. Does anybody else on the committee have a strong feeling? So I guess the question for Tom and folks is whether to continue to noodle on coming up with factors that would qualify. I probably be in any event a non-exhaustive list of factors to consider in what makes somebody coerced to commit a crime, or should we sort of
maybe wait to see if the bond bill passes, because it might be a different set of factors. If
we think almost certainly it will not pass. I mean, we can definitely will, but I don't want to put my finger
it will
on
not. Oh, would you say it will not pass?
I think that's the sense, but Tom,
what's the bill number? I think that the results are out.
Oh, nice. This is Mary's super expertise.
What's the bill number?
Let me look it up.
Oh wait, it's in alphabetical order. I should be able to find it.
It's also, I think it's the second or third time this has been tried in recent memory, you know, and sometimes that's what makes the difference. But to the
although it's all new members, I think that works better when you have members who've already been educated on an issue. That's my
good point.
Forgive me if I'm mistaken. It would merely extend the defense to violent cases. It doesn't do anything to define what coercion is, which is what our issue was.
Correct. It's AB 938, Mary.
Okay, hold on. Let's see.
So Heidi, did you gather that? So our task would sort of be the same.
Right.
It passed.
Yeah.
It passed the probes, but
so
I don't know. Maybe it would be I guess it would probably be similar, but I don't know. Maybe, yeah.
I
don't have a strong feeling about it.
I think that's a good idea because I don't know. The real problem is basically Rick and I don't want to just, you know, be out on our own on this. We'd like to get real feedback from the folks who've been working on this, and so far we haven't been successful about that. So I don't know.
Well, we have some time. I mean, you haven't been successful because they haven't gotten back to you, or because they don't have recommendations.
A little bit of both, I think. Rick, what would you say?
More of that. We don't have recommendations. Like Jamie Beck, who came and appeared before the committee last hearing, she's been, you know, very communicative about it. It's just that nobody really has a strong feeling about whether including additional factors in the statute would really make it super more helpful, and, you know, what exactly those factors would be. And so, you know, and as Tom mentioned, most of the energy in this space is about applying the defense to more felony offenses, not really establishing these factors. When we talk to people about these factors, there's some general like, okay, that sounds good, but nobody's really over the moon about it and doesn't have any strong recommendations for what they should be or how helpful they'll be.
My instinct is that a non-exhaustive list will help, and that especially if it's being expanded, all the more reason to help. I'm very sympathetic to the idea that people who've thought long and hard about this more than I have don't have recommendations, and therefore we should kind of wait on them. On the other hand, a statute out there without I'm inclined to try to keep on pressing on the experts on, can we come up with a non-exhaustive list of a handful of guideposts that will be useful? That's, I guess, where I come down on, but because the alternative is just to not do anything, which may be the wiser course. Do Mary, Peter, Heidi, do you have a thought?
No.
Sometimes it seems that sometimes when there's new things, it can take years to figure out where there's flaws in them, which isn't great for the current cases. But I can see why maybe experts don't have the idea of a list yet if it hasn't been, if they haven't been implemented, if it hasn't been used a lot, to find out where somebody thought it should have been, but it wasn't because of something. That's I mean, I can see why they're not so, but if people can't come up with factors, then it might not be bad to get ahead of it. But a lot of times it's just been my experience that stuff shows up down the road.
Heidi? All right.
I could go either way.
So I guess Tom and Rick, like not front burner, but let's keep our ears open. Let's keep our eyes on this bill, obviously. And if somebody comes up with some brilliant recommendations on factors to consider, again, I think we're pretty much in the agreement that we non-exhaustive list, that this is trying to prime the well. That would be useful.
Makes sense. All right. Number 3, this is a pretty small one despite the length of the text here. So sort of related to the coercion offense, we also talked a little bit about the post-conviction relief that's now in the penal code for people to vacate their conviction if it's based, if it was resulting from intimate partner violence, sexual violence, or trafficking. And we had some discussion about whether appointing counsel would be good in these cases, and I think in particular whether courts already can appoint counsel in these cases. We went pretty far down that rabbit hole. And, you know, upon further reflection, I think we realized that there is a law that went into effect this year based on a committee recommendation from two years ago that said, sort of created default rules for post-conviction motions of all kinds that the legislature could override if they wanted to, but if they don't, there's sort of going to be this this default. And one of them is that a court should consider appointing counsel for all post-conviction proceedings in an ameliorative statute. These motions to vacate are not actually listed as one of the example ameliorative statutes, which, to build on the theme, was a non-exhaustive list. So our conclusion is that this would definitely be one of the ameliorative statutes that would trigger all these defaults, but we could recommend a very simple amendment to that list to include these motions to vacate, remove any doubt. So I don't think there's a need to do anything really beyond that, except to say, look, existing law covers this, and let's just, you know, belt and suspenders make that entirely clear.
Sounds good.
All right. You know, Assemblymember Brian, when he was here, he seemed to indicate a lot of interest in doing something like that, maybe in this session. So maybe I'll reach out to his office and see if it's something they are interested in.
As long as we can, we don't close the list. Let's make sure that's not.
Yeah, the list is very clearly, this is, you know, it's already quite long. It says it's not, you know, exhaustive. So, you know, one more. Okay. All right. And then this is the last one on these sort of research updates. We had a presentation from the California Policy Lab last time that presented a lot of information about women in our prisons and the sentence type and things like that, and sentence length. And there was a question about how we compare to other states, particularly with life without parole sentences. So we were able to, with our partners at the California Policy Lab, get some data from the Sentencing Project, a report they had done a few years ago about the number of women serving life without parole sentences in every state. And that's what we have here. Let me know. I'll try to make this, it's kind of hard to see because it's 50 states. So what we did is we adjusted for population. So this is the rate of women serving a life without parole sentence in the state per 100,000 women in the state. So when you do this, we see that California, we're basically in the middle, though our rate is much lower than the places at the top, like Mississippi and Louisiana. So we have, less than one woman serving LWOP per 100,000 women in the state. You know, Mississippi has 6, Louisiana has 5.5. So I just wanted to present this because there was some interest in this particular amount of data. You know, again, what's the difference between someone with a 100-year determinate sentence and a life without parole sentence? This doesn't try to account for what are called virtual life sentences. This is just purely life without parole in that state as they answered the question. So, this is in the memo we sent out too, if anybody wants to take a closer look. All right. Now we'll move on to, we have one more developed proposal from last time. This has to do with self-defense and IPV, intimate partner violence cases. So I think this looks very similar to the staff recommendation from April and what you all had discussed last time, but also I'll tick through it very quickly. So first of all, this would only apply when the defendant is accused of killing their abuser, and it was in the killing, the argument would be, was used to prevent or escape a threat of ongoing life-threatening domestic abuse. So we would narrow any of these changes to that scenario already. And then the change beyond that would be to make two elements right now that are prerequisites that you have to sort of prove before you can even argue to the jury that there should be self-defense in your case, that there should be a self-defense instruction. And instead of making those prerequisites, make them something that the jury considers as part of the determination of whether the self-defense was objectively reasonable. And that would be the imminence requirements and the fear alone requirements. Right now, under California law, to use self-defense, there has to be an imminent danger that's about to happen, meaning it's going to happen instantly. It can't be something that has to be hours or days in the future. It has to be something that's minutes away. It has to be instant. And there's also a requirement that you can only be motivated by fear alone, which also can be overly constrictive in these complex IPV cases. So what this would do, it allow juries to more fully consider all the circumstances in these cases, and it would be similar to some how the laws in some other states, including Georgia, Maryland, Oklahoma, and Washington. I know that was a mouthful, so please let me know if there are any questions, and I'll let Rick answer them because he has a better grasp of it than me. If not, we'll
no, I think
consider
this
this
is good. I
done.
just want to make sure that we're clarifying. I know that we're seeing this through the IPV lens, but it would apply to anybody who's an abuser. He doesn't need to be an intimate partner. Is that correct, Rick?
Yeah, I think that we have it right now just using the language abuser, and we're referring to domestic abuse. So I think that opens it up outside of the context of just partners, and it could be, other types of household violence.
Right.
I think this looks right. I mean, the idea, the imminence issue is a tricky one. I think that we can to help to, especially in these types of cases, and I'm full support of trying to clarify / expand what the concept of imminence is and fear, and expand the idea of what reasonable fear is, I guess is the way I think about it. Which is what we're trying to do.
Yes.
Okay.
All right. And then that's it.
All right.
Public comment.
Thank you all. It's now come to the time for public comment. If you are here in person, I don't think there's anybody there in person, but if you are, let us know. For those of you listening on Zoom, to get in line to comment, please select the raise hand function. If you're calling in, please hit *9. Note that this meeting is being recorded and your name and telephone number may be displayed. Written comment is always preferred and more substantive, so email Tom at tnosowitz@clrc.ca.gov. With that said, please get in line, and then I'll decide how much time we have for each speaker.
Not seeing any hands.
I don't see any hands. This would be a first.
Friday before 3-day weekend.
Yeah. All right. With that said, thank you, everyone, especially Tom, Rick, and Joy. Thank you for all the hard work. Mary, welcome. I look forward to finding a way to convene in person. Everybody have a great long weekend. I really appreciate everyone's time and work and afternoon on this stuff. So thank you all.
Thank you.
All right.